2015 Court of Appeals is now in session. God save the state of Texas and this honorable court.
Thank you. Please be seated.
First, I want to thank University of Texas Law School again for hosting our homeless court, and we're pleasure to have you here with us. We've got a number of cases on the docket, so we'll get right to it. Move this aside so I can see you folks. First, we've combined two cases for oral argument, State of Texas versus City of Austin, State of Texas versus City of San Marcos. Court set aside 30 minutes to be split, 30 minutes for the state and 15 minutes each for each of the cities. Attorneys ready? You may proceed.
Good morning, Mr. Chief Justice, and may it please the court. My name is Cory Scanlon for Appellant, the state of Texas. The cities directly violated state statute by adopting ordinances that foreclose prosecution for criminal offenses. In doing so, they violated the sovereignty of the state and usurped the legislature's authority to establish its criminal law. The ordinances are not discretionary deprioritization measures. Inherent in the idea of prosecutors and law enforcement being able to establish their charging priorities is the ability of those authorities to pursue low-level offenses as higher-level crimes are resolved. But these ordinances remove the possibility of prosecution for those offenses, tie the hands of police officers by prohibiting arrests for those offenses, and have the practical effect of nullifying Texas criminal statutes within the city limits. These ordinances categorically restrict rather than uphold the discretion of law enforcement, and city officials should be enjoined from enforcing them. I'm going to cover three things today. First, how the ordinances are preempted. Second, how standing and immunity pose no barrier to granting the temporary injunction. And third, that Texas has met all of the required elements to establish.
Before you do that, let me just ask so prosecutorial discretion, familiar with, prosecutor decides whether to press charges or not. Police officers also have discretion, decide whether to charge somebody or to give them a warning, or is that only when I'm stopped in traffic that they have that kind of discretion?
No, Mr. Chief Justice. I think the line of cases that my friends on the other side have pointed to are cases in which private litigants have attempted to sue police authorities for failing to exercise their discretion. And we certainly wouldn't disagree with that idea. But in this case, the issue is whether they have the discretion to make an arrest in the first instance.
Would the state have the authority, if the state wanted to take away all discretion and say you must, like for murder or something, say, you must prosecute all murder charges? Like, is that something the state would have the power to do?
I think the state would have the power to do what they've done, something similar here, where the DA is not going to adopt any policy where they're not going to fully enforce the murder laws.
So this isn't like Castle Rock where you've got a private party trying to compel enforcement. This is the state.
That's correct, Your Honor. Starting with the text of this provision, it applies to the governing body of a municipality or a municipal police department. It says that they may not adopt a policy under which they will not fully enforce laws relating to drugs. Now, contrast that with the language in the ordinances and the provisions in the ordinances. By their own admission, these are ordinances to, quote, eliminate low-level marijuana enforcement, end quote.
So under Texas law, if I understand your position, the police, city officials, they have discretion whether to prosecute, but the ordinance takes away that discretion to be able to prosecute these low-level offenses, basically, right?
That's correct, Your Honor. And I just clarify that the ability to exercise that discretion in the first instance is what's being taken away. And the ability to exercise that discretion on a case-by-case basis is appropriate. But what the cities have done here is issued a blanket policy that certain offenses they're not even arrestable. You can't arrest someone for possession of marijuana. The other point is that there's no discretion for law enforcement or prosecutors to charge a Class C paraphernalia offense in lieu of the Class A or B offenses, and that officers will be disciplined under these ordinances if they don't comply. In San Marcos, there's another limitation on officer discretion by saying if you have the odor of marijuana, you can't institute a probable cause search for that. So when analyzed side by side, the court can easily conclude that the legislature has preempted ordinances like those here with unmistakable clarity.
Does the
Could-
fully, go ahead.
No, you go ahead.
Does the fully enforce language prohibit what you were just talking about, charging, for example, a Class C paraphernalia charge for what would normally be a Class A possession charge?
I think what I was getting at, Your Honor, was that they have to have the discretion to be able to use that in lieu of a more serious charge if that's what the prosecutor wants to do. The fully enforced language isn't really a barrier for the temporary injunction because the language read in its full context is not a bare mandate to fully enforce the drug laws. It's that the cities cannot adopt a policy whereby they are not going to fully enforce the drug laws.
What if the situation were a little different? I mean, in reading the briefs, there was a lot of explanation about how hemp products are not being tested anymore for misdemeanor amounts by law enforcement. And so what if it was just the prosecutor, in this case the county attorney, sending a memo to the police officer saying, look guys, I'm not prosecuting these anymore because I can't get tests done. Would that be afoul of the statute?
It's likely that would if it was a blanket policy that said these offenses are never going to be prosecuted. When we questioned the city authorities in both cities, they both admitted that there are different ways to prove these offenses. There's not necessarily going to be testing in every case. And when you look at the language of the ordinance compared with the language of the statute side by side, the legislature's test for unmistakable clarity is met. I'd further add that it's the intent of the legislature to preempt. It doesn't mean that the language has to be crystal clear for preemption to apply. The cities below had argued that you have to basically establish preemption in all applications, which is not a correct recitation of the test.
And so seizing the product is not fully enforcing in the state's view?
That is one measure of enforcement, but if you have a police officer, they have the tools in the toolbox for enforcement. That would include arrest. And saying that you're still enforcing the law because you can seize it, or you can still make an arrest because of these exceptions for a felony narcotics or a felony, violent felony crime, is a little bit like saying, in our city, we're not gonna issue anybody a speeding ticket unless they happen to run somebody over. So the authorities have to have, like I said, all of the tools in their tool belt. They also said that they can't plea bargain, or, well, this is what the city of Austin specifically said, that they wouldn't be able to plea bargain or offer diversion, but they can't do that under the ordinance for these crimes either, because there's no defendant to plea bargain with if you don't arrest them. The city of San Marcos has kind of addressed this by saying, well, the ordinance or the statute doesn't say that local ordinances are expressly preempted. That language is not a requirement to find preemption. I'd cite the court to the Laredo Merchants, the city of Beaumont v. Vahl case, and the BCCA appeals group in which that language wasn't necessary to find preemption. Turning kind of to standing, the city hasn't really grappled, and standing is only argued in the Austin case. San Marcos hadn't brought it up. In Ray State, that we cited in our brief, standing is established at the temporary injunction stage for violations of state law by local authorities. That automatically results in irreparable harm to the state, and the state has a justiciable interest in its political subdivision's compliance with Texas law.
Could we talk a bit about who the proper parties should be to this case? So I know that the ordinance has already been approved you can't really unapprove an ordinance, right? Or how does that work within the framework of what type of relief can be obtained against city officials?
Sure, Justice Ferris. So all of the defendants to this case are proper parties through the judgment that we're seeking. We are asking to enjoin all of the city officials from any further acts of implementation and enforcement of the ordinances. The city manager oversees the chief of police, so they have control over the chief of police. The city councils can fire the city manager at will with some limitations under both the city's charter. The Declaratory Judgment Act says that the city has to be sued
Sure.
to challenge the validity of the ordinance. So we've got an entitlement to injunctive relief on one side and entitlement to a declaratory judgment on the other side.
So your relief is going to be declare the ordinance, or whatever in each case, to be preempted and to enjoin or the officers from enforcing it or following such a policy.
Yes, Your Honor, and there's further acts of implementation that we would ask to enjoin. Both police departments have passed specific policies. We'd ask the court to enjoin any other policies or procedures that have been passed under these ordinances. I think that the declaratory judgment also makes this kind of redressable if the ordinances are declared void.
So what's the difference? Probably the police officers know what their bosses want them to do. We tell the bosses, stop doing that, we declare the statute, but if the individual officers want to choose in their discretion not to prosecute anybody for minor drug or marijuana offenses, they'll keep on doing whatever they want to do.
It's possible, but the real harm here is to the sovereignty of the state. So clarifying the policy, what the state of the law is. And we also had the chief of San Marcos Police Department testify that his officers were not making arrests that they otherwise would. I would cite to pages 52 through 53 of the second volume of the reporter's record.
Thank you.
And I also think that just kind of turning to San Marcos's argument about they're not proper parties to the injunction because they did not adopt a policy, I think that's really not much more than a magic words defense. The chief of police in San Marcos was apparently instructed that as long as he didn't use the label policy in issuing his memorandum, it would be rendered legal. It's unclear exactly what the city means in making this argument. It's either that the word policy doesn't include an ordinance, or it's that none of the officers or the city council committed an act of adoption. Either way, that argument fails. An ordinance is obviously a more specific item of legislation that can be included within the meaning of a policy, and the record undermines the city's argument about adoption. At Volume 3 of the reporter's record, pages 46 through 49, the resolution that was signed by the mayor stated that it will be effective immediately upon adoption and that it was considered, approved, and adopted right above the mayor's signature.
Does the city have discretion when the citizens have an initiative that leads to a vote and they vote for something?
I think they do, Your Honor. We saw that with the city of Bastrop, the letter that I filed earlier this week. It's clear under both cities' charters, under the Texas Constitution, that if a provision is going to run afoul of the Constitution, the city council has the authority to reject that because, again, if it violates the Constitution, it can't be given any practical effect.
Well, but I guess they're going to get sued either way, right? If they.
I
If
don't
they
know
do or
that
they don't.
for
Okay.
certain, Your Honor. It's definitely a possibility. We've seen lawsuits on this issue. There's multiple cases working their ways through the courts right now. So I don't think that lawsuit would go anywhere because I think under Glass v. Smith, the Supreme Court has said that the legislature may withdraw certain subject matters from the field of the initiative, in which case they wouldn't be penalized for doing what the city of Bastrop did. So although the courts have certainly reflected a lot of respect for the initiative, in such a case as this, where the statutory prohibition by the legislature on its home rule cities is so clear, I wouldn't think that lawsuit would go very far. I've been wrong before, but San Marcos, I think the issue about kind of relying on the voters and saying there's nothing we could do, if that's taken to extreme, it's kind of an absurd result. A court cannot declare an ordinance unconstitutional when it directly conflicts with state law anytime it receives voter approval as an initiative. That would kind of be the rule here. There's no support in the law for that. San Marcos, this issue kind of also conflates the voters' right to have an election called, which in this case, the court doesn't have to decide whether that could have happened or not, with the implementation and enforcement of the ordinance, which is all we're asking for here.
Aren't we, I mean, do we have a danger here that we're wading into policy decisions by a government body where the citizens themselves are recognizing a lack of police protection and wanting police officers to stop violent crime, things of that nature, and use those funds for that rather than misdemeanor marijuana enforcement? I mean, where does the line there of local control versus state intervention?
To answer the question, Your Honor, I'd say no. We're simply asking the court to apply the preemption statute that we've cited, Texas Local Government Code, Section 370.003. But the issue about where the line is to be drawn, I think, could maybe be more challenging in a future case. But in this case, the court can say with certainty that an authority is not fully enforcing the drug laws if they're not even allowed to arrest them. So to the extent there's challenges regarding allocation of resources or priorities or arrest decisions, that's really not what this case is about at bottom, as I kind of mentioned at the.
What do we do with the language in Castle Rock that, fully enforced can't mean fully enforced?
I think, Your Honor, like I mentioned, the fully enforced language doesn't have to really be specifically defined by the court. The prohibition here is adopting a policy under which the entity will not fully enforce. So to the extent we agree that there's never going to be 100% enforcement, maybe in some places, that really kind of just means that the public's expectation of full enforcement has to be there. That's represented in our laws. Texas Code of Criminal Procedure, Article 2.13 says officers shall make an arrest without a warrant in cases in which they're authorized. So I think you start with the presumption, and the public has to have the presumption that they're not going to be able to rely on an officer's discretion to be able to commit a crime. I think that's all that the court really needs to say on that issue.
Isn't there already discretion, though, in this context, given that you can't tell when you see a plant if it's legal hemp or if it's marijuana, because the definition is the THC percentage, and you don't know that until you test the plant. So don't we already have a lot of officers who would see marijuana flower potentially that could be hemp and just go, yeah, I'm not touching this?
If that were to happen on a case-by-case basis, I don't think this ordinance would reach that, Your Honor. The challenges with resources, like I said, would have to be addressed on a case-by-case basis.
So the bottom line is it's really the prohibition contained in the ordinance for enforcement. It's not a matter of do they have discretion or not. It's the prohibition of full enforcement.
Yes, Your Honor. I think that's correct. I want to talk about the constitutional challenges that the city of Austin has raised. They've raised separation of powers and vagueness challenge, due process vagueness challenge. The we start, I think, with the presumption that statutes are constitutional, and constitutional avoidance doctrine should kind of render those issues moot. I think that applies here, and also I'd add that the state doesn't have a burden up front to prove that a statute is constitutional. The separation of powers issue, there's really three reasons that that argument fails. First, cities are not a branch of the state government under City of Fort Worth v. Zimlick. The plain text of the separation of powers provision allows for some interplay between the branches when it is, quote, expressly herein permitted.
Would you have a separation of powers problem in the hypothetical I posed earlier, that the prosecutors had told the city, we're not prosecuting anymore? Because
No, Your Honor. This would be covered under the preemption statute because a prosecutor is one of the entities, and the separation of powers problem says if other provisions in the Constitution allow that interference with discretion, if you want to call it that, that's okay. So the home rule provision is kind of what would govern that. And it says, no charter or any ordinance passed under said charter shall contain any provision inconsistent with the Constitution of the state or the general laws enacted by the legislature of the state. The third point on separation of powers is that it's really the ordinance that interferes with discretion and not the preemption statute. The ordinance allows the authorities full discretion. So by taking away the tools of arrest and citation, you don't even have defendants you can really bring a full case against. That severely interferes with prosecutorial discretion. On the vagueness point, the city is not a person or citizen who can challenge statutes alleged to infringe on Bill of Rights protections. In other words, courts have long held that cities cannot bring a due process challenge against the state, and because the vagueness doctrine protects individual and not city rights, the city's vagueness challenge should be refused. Unless the court has any further questions.
Thank you, Mr. Scanlon.
Thank you. I'll see you on rebuttal.
Good morning, Mr. Chief Justice, and may it please the court. Section 370.003 of the Texas Local Government Code, which purports to prohibit certain entities from adopting a policy under which those entities will not fully enforce all laws relating to drugs, is vague to the point of being no rule at all. But given
Before we get started on that, do you agree with your opposing counsel's characterization of a vagueness allegation being a subset of due process, and that cities can't assert due process rights as against the state?
Not exactly, Justice Ferris. So the U.S. Supreme Court in United States versus Davis, which is a 2019 case, said that the vagueness doctrine, quote, rests on the twin constitutional pillars of due process and separation of powers. And again, in Sessions versus DeMaya, 2018 U.S. Supreme Court case, also said that the vagueness doctrine is a corollary of the separation of powers, requiring that Congress or the legislature, rather than the executive or judiciary, define what conduct is sanctionable and not, or what is not. And so, in other words, the vagueness doctrine comes out of both due process and separation of powers.
But if we didn't if we didn't agree with your line of argument on separation of powers, then the only prong we would have left would be due process.
I'm not sure I follow Justice Ferris. So there's
Yeah.
kind of two
Sure.
and maybe more than two separation of powers concerns. So one is a separation of powers challenge to the legislature purporting to control how prosecutors prosecute. And then there's also the vagueness of the statute itself, which comes out of both due process and separation of powers.
Mhm.
So I'm not sure I'm answering your question exactly.
No, I think that's it. I was just saying, if for instance, if we don't agree with you on the separation of powers arguments, would the only hook for vagueness be due process? And so would we need to rely on due process?
Right, so I think if you could disagree with me that the statute improperly interferes with prosecutorial discretion, but still agree with me that the law is so vague that it presents a separation of powers problem. Because it is in effect asking the court to write the law for the legislature. So I'm here to advocate for I just said that this law is unconstitutionally vague, but I would like to advocate for a limiting construction under which it should be properly understood to mean that regulated entities cannot adopt policies of blanket non-enforcement of misdemeanor marijuana possession. Or in other words, that some enforcement mechanism must remain for misdemeanor marijuana possession. And seizure is a form of enforcement. So enforce means compel compliance with the law. And by seizing suspected marijuana, that is compelling compliance and stopping the possession of the suspected illegal marijuana. So seizure is enforcement. And Austin Police Assistant Chief Eric Fitzgerald testified at the temporary injunction hearing in this case that enforcement mechanisms run the gamut from police presence alone all the way through custodial arrest.
Well, but that's, the vagueness rule applies only if you can imagine the circumstances where it would be vague, but if you certainly knew it applied to you, and just reading, that they can't make arrests or citations, they certainly knew what they were doing violated that. I mean, that's perfectly clear.
I disagree, Chief Justice Brister, and here's why. And I think it got to the court's colloquies with my friend on the other side about whether the law prohibits an officer from exercising discretion or not. Because my friend on the other side says this law does not prevent individual officers from deciding whether to arrest or cite for misdemeanor marijuana possession. But the law, the 370.003, could equally be interpreted to require arrest or citation in all instances of misdemeanor marijuana possession with probable cause. And so that is vague.
Well, but the statute just says cities can't have such a policy. It's not directed at police officers.
But if, let's say, the city has a policy under which it will leave it to the individual officers to decide whether to arrest or cite, that could be interpreted as a policy under which the entity will not.
But isn't that what you had before the ordinance was passed? Like there was that discretion, and then the ordinance took away discretion in some instances to use certain tools?
I suppose so, but then the question still remains, does 370.003 prevent that limitation and cabining of discretion? Particularly when officers are still enforcing through seizure. Going back to 370.003 and whether it is vague as applied to the city, back to the Chief Justice's question, another, I think, way to get at the vagueness as applied to the city is that the ordinance also prohibits using city resources for testing misdemeanor amounts of marijuana for THC concentration. And the state is seeking to invalidate all of the ordinance. And so the state is saying even those kind of funding decisions are preempted by 370.003. And then what's to prevent the state from saying, well, anytime the city council adopts a budget under which 100% of its budget is not devoted to drug enforcement, that is council adopting a policy under which it will not fully enforce.
Well, again, that's not the case in front of us, and then we'd have a vagueness problem. But vagueness, when it says you can't have a deal that says no citation or arrest for misdemeanor, That's not vague in our case.
But I think it's telling that the state says, oh, don't read this literally. We can't actually rely on the words on the page. Fully enforced doesn't mean fully enforced, because obviously that would not work. So I think we are still left with this vagueness problem in the statute. And then as a preemption matter too, even just setting aside the vagueness issue, as a matter of preemption, under City of Beaumont versus Vahl, a local law and a general law are not to be held repugnant to one another if any other reasonable construction can be reached. So I think, again, a reasonable construction of 370.003 is to prevent blanket non-enforcement of offenses, and since the Austin ordinance does not do that, they can coexist. And I wanted to touch too on a little bit of the context here, which Justice Field alluded to, which is that in 2019, Texas legalized hemp and changed the definition of illegal marijuana to exclude legal hemp. And definitionally, legal hemp is the plant, the cannabis plant, and any part of that plant with a THC concentration of not more than 3%, 0.3%. And so the only way to know for sure whether a substance is legal hemp or illegal marijuana is through testing. Can't be done through sight or smell alone. And so this ordinance grew out of that kind of legal landscape. And I wanted to touch too on the kind of citizen-initiated ordinance process. I strenuously disagree with the state that the city is able to just look at a petition and say, that's not gonna work, and toss it out the window. It has to, once it has the requisite signatures on the petition, it has to call the election, and it has to canvass the vote, and I think it would be mandamusable violation of the elections code not to canvass the vote, and which.
So even if you had something just blatantly unconstitutional, like, there's an initiative to ban women from voting, the city still has to go through the process and approve that?
Yes, it would not have to enforce it, but yes, it would need to have the vote and canvass the vote. Hopefully it doesn't pass, but.
Right, but do they have to pass the ordinance? That's the question. I mean, they have to canvass the vote, I understand that, but then the ordinance still has to be approved by the city council. Do they have to do that?
No, Justice Ferris, so the canvassing is the approval of the ordinance.
Okay.
And I may have just called you Justice Ferris, may I?
That's okay.
Sorry, I apologize.
That's all right.
So, and that's another curiosity about this law is it doesn't say that any contrary ordinance is unenforceable or preempted. It just says cities can't adopt a policy, but it doesn't say what happens specifically.
So the city of Bastrop was just way out of line, like they didn't have, can you explain why what city of Bastrop did was wrong?
Yes, I mean, the city of Bastrop, I think, I'm speculating here, but I think they thought they had a 100% likelihood of being sued by the state if they canvassed the vote, and maybe a less than 100% chance of being sued if they didn't, and opted with the latter. So I guess with my remaining time, I'd like to touch briefly on some of the requested relief that the state asked for, because it goes, I think, well beyond what is permissible. So for example, one of the things the state asked for is a temporary and permanent injunction ordering the city defendants to repeal its own ordinance. And that's just not an available form of relief. The state could, if the state's right that it's preempted, it could get declaratory relief that the ordinance is unenforceable, enjoin enforcement of it, get relief that it's void, but to reach out and require the city of Austin to repeal its ordinance, that is, again, a separation of powers problem. And the Pigeon versus Turner case speaks to that. And then its other requested relief, so it again, doesn't simply request that the ordinance and corresponding APD policy be enjoined, but another component of relief it requested in its petition was an ordering the city of Austin defendants to fully enforce the drug laws in Chapter 481, which what does that even mean? And then that runs headlong into the problem kind of described in the enforcement priorities case of not having standing to order a body to effectuate more arrests.
So would you agree that the state law in question, if, assuming for a minute that it's not vague, the state law imposes or prohibits imposing a bar on full enforcement, but it does not mandate full enforcement, right?
I guess I'm stuck, Justice Ferris, because I think it is vague, because I don't think you can tell whether it prohibits discretion on the part of officers to arrest or cite.
Okay.
And I think the state is saying conveniently and trying to appear reasonable, saying that it's not, but I don't think you can get that from the statute.
But what the Texas Constitution says is no ordinance passed under city charter shall contain any provision inconsistent with the Constitution of the state or the general laws enacted by the legislature. It doesn't say they can't be enforced. It says they can't have them. No charter shall contain any provision inconsistent with state law. Now, how are you going to comply with that constitutional without ordering repeal?
I think that if a law is deemed unconstitutional, it's a nullity. It's as if it doesn't exist. So I think that's the way to square those two concepts. But I still maintain that ordering a legislative body to repeal a law, if it were the state of Texas and someone told us.
But then you would be it says you can't have an ordinance that contains a inconsistent provision. And so, in fact, you can.
I see I'm out of time, but
No,
yeah.
I'm puzzled. Your position itself would violate. Your solution that you can't repeal it would violate that clause because it allows the city to keep a provision that's inconsistent with state law.
And I go back to a void law, an unconstitutional law is in effect no law. So I guess it's maybe.
So it gets a little red flag on Westlaw, basically, right?
Thank you.
Thank you, Ms. Hale. Ms. Smith?
Morning, Chief Justice, and may it please the court. I want to start maybe with the question you posed, Justice Ferris, about whether or not this statutory provision, section 370.003 of the Texas Local Government Code, talks about prohibition. And I think that it does. It talks about you may not adopt a policy that prohibits full enforcement. This statute is about prohibition. It's not about affirmative obligation or affirmative requirement. I think that's really important when we're talking about relief that's sought to fully enforce the drug laws of the state. That goes well beyond what the statute requires. And so I do want to take a bit and do a bit of a reset, because I know we've kind of gotten into the weeds about what certain enforcement measures look like, but I want to make clear that this case is not about marijuana, but it's about the questions before the court that center on immunity and municipal governance. So I know your honors are all very familiar with governmental immunity, so I won't get into a primer, plus I don't have a whole lot of time today. But I think that it's important to remember that we start with immunity when we're talking about government officers and governmental entities. Waivers are exceptions, immunity is the rule. And in order to have waiver, you have to have that validity to what you're challenging. So let's say you have a concert ticket and it's to your favorite band, you have a ticket for Thursday night, you try to use it on Friday, you can't use it, right?
Well, can the city be sued to declare an ordinance preempted?
The city can under the UDJA,
Under
yes.
UDGA, right.
Yes, but even then, you still have to have a valid challenge to the ordinance in order to survive a jurisdictional challenge.
Right.
And that, we don't have that here, right? This is like if we use a Thursday ticket on Friday. There is no valid ticket for entry here. And so we have two buckets. We have bucket one, we're talking about a city being sued for preemption. We have bucket two, talking about ultra vires acts by each of these government officials, right? And so I said bucket two, but I'm gonna start with bucket two as bucket one. And so I wanna go back to section 370.03 again and what it says. It enumerates certain entities or certain officials, you know, the governing body, the city council here, commissioners, court of a county, sheriff, et cetera. And it says then what they may not do. They may not adopt a policy. What can they not adopt a policy to do? They cannot adopt a policy under which the drug laws of the state will not, and also under federal law, will not be fully enforced. And I think that's important because we've talked a little bit about this morning, you know, the state law, but I think with Justice Field, I think he brought up the change with the Farm Bill and the legal definition of hemp. We also have House Bill 1325 that was passed in 2023. And again, I think that what the citizens here have voted for, and I want to be very clear, the citizens are who adopted this. It's not the city council, it's not the mayor, it's not the police chief, it's the citizens of the city of San Marcos who adopted this.
But the state can't just randomly pick a citizen and sue them, right, to obtain relief.
No, but I think
Right.
that the problem we have here is the state filed a lawsuit that doesn't cover the realities that exist. So here we have a citizen initiative that was, the citizens did what they're supposed to do under the city charter. They went and got their petition, they got all the requisite signatures. And in fact, I know that Your Honor also posed earlier whether or not the city had discretion and whether or not to hold the election and to certify the results. They absolutely have to hold the election and certify the results. Glass v. Smith, that's been on the books for, you know, well over half a century, says this. But even last year in N. Ray Rogers, the court again said that.
I'm sorry to
Yeah.
interrupt you. Your position is 370.003 says governing body, commissioners, court, sheriff, police, county attorney, district attorney, criminal court may not adopt a policy. Aha, we found a loophole. The people can adopt a policy. That's your argument.
It's not a loophole, Your Honor, I think, but it might be, as in the state might be pointing out that it thinks there's a gap in the statute. But, and as much as I respect each and every one of you, the way we fix gaps is not here in this courtroom, it's down at the Capitol building. So to the extent that the state thinks that there's a gap and that there are other ways that this should be solved, and we know the legislature knows how to do something that is not so specifically spelled out and enumerated because they have in other statutes in the Texas Labor Code. It's Texas Labor Code section 62.0515.
Where in the record do we have the, I understand you got the canvas is where you say this is the official count, the ordinance passes, it doesn't pass it. Where's the provision that says then it becomes automatically an ordinance? Is that in the record?
It is in the record, and I should have had the page in front of me.
That's all right, you can.
But it's in the city charter sections. It's 6.10. It says, if a majority of the legal votes cast is in favor of an initiated ordinance, it shall be effective as an ordinance of the city when the result of the election is declared. And so I
So
gave you
somebody
all,
still has to declare the result, right?
but declaring the results is declaring the results of everything that was on the ballot, right? It's the proposition that's on the ballot that results in this enforcement ordinance. Because there's really two ordinances we're talking about. The enforcement ordinance, capital O ordinance that talks about marijuana enforcement, and then there's the canvassing ordinance that just purely is a tabulation certification. Yep, this many votes for, this many votes against. And that's really all that ordinance is. And I know that my friend here, Mr. Scanlon, talked about the city adopting and approving the capital O ordinance, the enforcement ordinance, but that's not what it was. If you look at tab A of the exhibit binders I presented, you can see the full text of the ordinance, and it makes clear when you have all of the context that what the city council and the mayor approved was just, here are the votes.
Well, so
this
why
many-
do we have this language, be it ordained by the city council? Then, like, I mean, if nothing more was required of the city officials, why do we even need that language?
Well, because they have a ministerial obligation to canvass and certify the votes.
So they are doing something.
They are carrying out their ministerial obligation to certify the votes, but they are not, so under the city charter as well, when they get a signed petition, the city council has two options. Option one is that they can say, we're gonna vote on this and decide whether or not this is an ordinance that the city council itself is adopting.
Right.
City council didn't want to adopt the ordinance, in fact, affirmatively did not do so. The only other option is saying, well, the people want this, so we have to put it on the ballot and let them decide. And that's exactly what happened in this case. So there was no affirmative act of adopting here by the city council. All it was them carrying out a ministerial obligation. And when you asked if they had an obligation, they did. And in fact, if they hadn't done that, that had probably been ultra vires, right? Because they have a ministerial obligation to certify the election. And that's a pretty good lawsuit, I'll tell you that. But they didn't do that here, so.
But that argument goes fully to the ultra virus action that doesn't dispose of the immunity with the UDGA and the validity of an ordinance. How do you get there?
Absolutely. So, yes, I mean, so ultra vires action, easy. None of these people took any action to adopt a policy. And I also have Chief Standard's full memo as a tab B for you all, so you can see that there is no policy that was adopted. It was purely a communication of, here's what the folks did here in San Marcos, so their officers are aware. And so as far as the preemption here and the UDJA, Justice Field, there's also not an inconsistency here because, contrary to what my colleague said, there's not necessarily magic words that it has to look like, you know, this is expressly preempted. But that often is what it looks like. And we know that because we have clear examples from the Texas legislature that have showed us what it looks like when the legislature does want to clearly and unmistakably preempt a field. So we have, like I said, Texas Natural Resources Code, section 81.0523, that says that the authority of a municipality or other political subdivision to regulate an oil and gas operation is expressly preempted. That's a good example of unmistakable clarity. And I know that my friend here, Mr. Scanlon, also pointed to the City of Laredo versus Laredo Merchants case, and I think that's another good example because the City of Laredo is, you know, we're all familiar with the shopping bag bans here, but the Texas legislature went back and passed the Solid Waste Disposal Act that does have language and that says a local government or other political subdivision may not adopt certain ordinances, and that's in Chapter 361 of the Texas Health and Safety Code. And so that's another example of where they're clearly trying to have broadly prohibit a city government from adopting certain ordinances. Again, this statute looks different, and it looks different for a reason because it is different and it should be applied differently. And so when we talk about as well the language of fully enforce, right? Fully enforce means, like Ms. Vahl said, to stop, prevent criminal activity. It does not mean arrest. It does not mean citation. When Chief Standridge...
But it could include those things, right? I mean, if I want to fully enforce the policy that my daughter will do her homework, which sometimes happens and sometimes doesn't, but mostly happens. If I am saying like, okay, I will never take away your phone in support of carrying out this policy, you know, is it really fully enforcing when you're taking a tool away that state law says you should have? I mean, full means complete, right? 100%. And so isn't it at least conceptually possible that this ordinance is taking away the capacity for full enforcement, even if it's still leaving some discretion in play?
I think there's an ordinance that could do that. I don't think it's this ordinance. And the reason why I say that is because not only does it still allow seizure and destruction, which are methods to prevent and stop criminal activity, but it also doesn't remove citation and arrest in all circumstances. So if it's in the during commencement of another felony, narcotics offense, or there are certain instances where you can still cite and arrest even for these low-level offenses. So it's not in all circumstances, and it's, again, the citizens expressing the will of, hey, we have, violent crime we would like the cops to go over here and focus on. And I think that when you look at the statute, and it does still allow citation and arrest in the circumstances, all of that is in harmony. And I think, again, it's in harmony with other state laws, in harmony with the way federal law looks today. And so it's not preventing full enforcement. It maybe makes enforcement look a little bit different, but it makes enforcement look like what the will of the people want.
So is full in the eye of the beholder? And if so, is that in the eye of the state or is that in the eye of the city?
Full enforcement is, well, again, all the offenses are still in the books. So the offenses aren't wiped clean. The ordinance, the enforcement ordinance doesn't say these offenses just go away. It just means that how we allocate our resources looks a little bit different. So I don't think that full enforcement should be read, and this maybe goes to what is full enforcement, but full enforcement should not be read to create affirmative obligations here, because again, that wades into the purview of discretion. And so I have a little more time, but I want to talk about
So let me ask just the big question here. State law is supreme over local law, right?
Yes.
Even though we don't have a supremacy clause. And the only way the railroad runs is if everybody, like it or not, the U.S. Supreme Court does some things that all of us, left, right, middle, in between, don't like. But the railroad only runs if everybody, including all judges who've sworn to uphold the laws, say, well, that's what we'll do. And this doesn't look like that. This looks like a city or two that didn't like the drug laws on minor possession of marijuana, which they're entitled to that possession, and they may be right or wrong. But how do we run this railroad if local governments and local judges won't follow state law?
Well, again, I don't think that it's a failure to follow or comply with state law, because these offenses are still in the books. These offenses are still being enforced. They're maybe being enforced a little bit differently, but different is not no enforcement. And I would also say that
the enforcement is, we'll take away your marijuana or hemp, whatever it is. And as long as you don't do something where it's not part of a larger drug offense, you're not going to be prosecuted. That can't be full enforcement. It is enforcement of a type, I'll grant you that, but it's not full enforcement.
Well, I think when you're talking about full enforcement of the drug laws of the state, I do think that there is full enforcement that captures the whole statutory and regulatory scheme. And is overall, are we enforcing all of these drug laws? And again, it has to comply with state law, it has to comply with federal law, and so it's all of those that have to be read in harmony. And when you read all those in harmony, I think that this is full enforcement. And so since I am about out of time, I'll just say that, this is a case about municipal governance and the right of not just the cities, but the citizens to govern themselves. Because I want to impress upon you that these are citizen initiatives. And so here what we have is a clear intent to suppress the will of the voters and how they allocate their resources and keep their communities safe. And that's not what the statute tells us to do, and that's not what we should be doing, but that is what the state is asking you to do.
Thank you, Mrs. Smith.
Thank you.
Mr. Scanlon, I believe you have 8 minutes.
May it please the court. What the city of Austin is asking the court to do is interpret the statute into a vagueness problem, and that's very clearly not how to follow the doctrine of constitutional avoidance. So the limiting construction argument on vagueness should be rejected, even if you even reach that question, because as I argued earlier, the city doesn't have due process rights that it can assert here. I think the standard that was proposed, that it's vague to the point of being no rule, while that is the civil standard, I think that you get there only if you find that there's a statute here that infringes on individual rights. The vagueness doctrine is meant to protect those rights, and it's not meant to protect against unfair punishment. And that's really ties back into the preemption question. the standard here is whether the legislature intended with unmistakable clarity to preempt with its intent, not necessarily with the language. And
Can you help me how we're going to order repeal of an ordinance? Because you're asking us to not just declare it unenforceable or improper or preempted, but to order repeal?
yes, Mr. Chief Justice, that remedy is available.
As some kind of affirmative injunction or a mandamus? You people get together and meet and repeal this and wipe it off the books?
That would be how it would happen, Mr. Chief Justice. I think the justification for that, as you mentioned, is in the Constitution, the statute itself, the specific prohibition we're looking at here, that they may not adopt a policy. I think that gives the court authority to order a repeal.
Is there a case where that's happened, where,
There was one with the city of Houston, and it wasn't in our brief, but it was.
You can
it was
just send it in a letter and you all can respond to it if necessary.
Well, it was
But
in their.
I mean, we're a brand-new court. That's fine. We hate to do brand-new laws that have never been done before, so.
Yes, Mr. Chief Justice. I can say about that case, the remedy of repeal was in the charter itself. So I don't know if that's directly on point, but with this being the statutory mandate, may be more appropriate at the permanent injunction phase as opposed to the temporary injunction phase. But repeal is an available remedy for state statute.
could we also talk about the temporary injunction relief that's been sought? As I understand, it was phrased as full enforcement.
It-
And you're arguing that the court could have ordered something other than what was specifically requested?
Well, Justice Ferris, the injunction seeking full enforcement is really just kind of alluding to the statutory language.
But the
here.
statute itself doesn't compel full enforcement, it just prohibits a bar to full enforcement. And as I understand, those are conceptually different things.
Yes, Justice Ferris. So it would be a little, I guess, let's say inartful to say fully enforce the laws, and we've taken the position, as you said, that it's really about preventing the policy from going into force. So
Well, I guess I'm just wondering, if this goes back to the trial court, would it just be cleaner to have a new request for a temporary injunction that doesn't say full enforcement?
the court can certainly remand with instructions to enter an injunction in line with the opinion or whatever the court rules. The Vahl case, the reasonable construction rule that they're talking about, if you have two statutes, doesn't really come into play here because there's an express limitation, and the cases have said if they're, you can maybe read them in harmony, there may not be a preemption problem, but here you have an express limitation on the authority to adopt this ordinance. So
I'm troubled by Ms. Smith's argument, so got a city council say, we're not gonna pass that statute, that ordinance, because the state says we can't. So the people get a petition, an initiative, referendum, and they've gotta canvass it. And so what are they can either refuse, it reminds me of a vice president being asked to refuse to count the electoral college votes, that puts you in a difficult position. So here there are people that are voting in and out of office saying, we've passed this, you need to canvass it, and the city council was supposed to say, no, we refuse.
Well, Chief Justice Pritzker, you don't actually have to reach that question here. We would submit that the acts of canvassing, declaring the results of, and adopting the ordinances are all distinct. And what the statute says is you can't adopt it.
So you've canvassed the votes, you said it passes, then what does the city council do to adopt?
They're basically saying that they're passing a resolution adopting the ordinance as a result
When
of
they
the votes.
canvass the votes, when they certify the results of the election?
Right, and I think the language that Ms. Smith brought up, that it's when they canvass the votes is when they adopt the ordinance. So you can canvass the votes, but you can refuse to adopt the ordinance if it violates the Constitution so clearly as it did here. Addressing the immunity argument, That's essentially foreclosed by Hollins. And just on the point about the arrest, if you're not arresting, you're certainly not fully enforcing. You may reach a measure of full enforcement if there's a citation, but I think that a prohibition on arrests for a criminal statute violates the prohibition in 370.003. The railroad certainly can't run on time if the measure of making an arrest is not available in the first instance.
Let me go back on the claim, on the ultravirus claim. If the adoption of the ordinance is the ultravirus act, then what's the prospective relief we would be enjoining for the ultravirus act?
As to the city council members,
Yes.
it would be further implementing the ordinance, passing any measures to further implement it, or taking any disciplinary action as against the city manager if the city manager refuses to implement the ordinance. Those are the kinds of prospective relief we're looking for. It's also, I think that the city council members need to be included in the ultravirus declaration because the statute says that they may not adopt the policy. So to carry that out, they would have, they're proper defendants for the deck action as well. Regarding the testing of THC, there's record evidence that that's not the only way to approve or to proof problems basically don't cause the inability of the officers to make an arrest in the first instance. And that kind of goes back to what Chief Stanridge testified at the beginning, that he was opposed to the ordinance. And I see I'm out of time. If there are no further questions, we ask that you reverse.
Thank you, counsel.
Thank you.
Thank you for bringing us two such interesting cases. It makes me wish for the days of presiding over car wrecks and slip and falls at the grocery store. I suppose that's not what this court was created for. So we'll take a brief adjournment, be back in about 5 or 7 minutes, and take the next interesting case. Thank you.
All rise.